Let's play red light, green light. Only not the one you played as a kid. This one's very much for adults. Here we go. If you haven't tried Curio Wellness cannabis products, that's definitely a red light. But it's also a green light, because Greenlight Dispensary Southeast is the new home of Curio. For the best flower and edibles in Missouri, ask for Curio by name at Greenlight. You've got the green light. Go.
For use only by qualifying patients or consumers at least 21 years old. Individual results may vary.
Welcome to Greenway Audio Magazine. I'm here with Brandon. And today we have a guest that we have been talking about for a long time. Eric Walter, legend in the industry, partner and cannabis law practice area leader at Armstrong Teasdale, another legend in the St. Louis, Missouri industry, in the law firm industry. I know. How long has Armstrong Teasdale been around? Because people have been talking about them forever.
Yeah, we're celebrating 125 years this year.
Oh, okay, I didn't know it was that long. Holy cow!
Eric's been there
Eric
for
Walter,
2/3
everybody.
of it.
Yeah, right.
Eric, thank you for joining us. We have been looking forward to this for a long time. We have so many
Original
legal
founding
questions.
partner at Armstrong Teasdale, right?
Thanks.
Yes, thank you. Thank you so much for joining us. So a lot is going on the legal side of cannabis right now.
Oh, yeah.
What?
Yeah,
Have
so much
things happened?
So much has happened. I know what I want to start off with, but Brandon, did you have anything you want to kick off?
Just for those that may not be familiar with Eric, Eric has won multiple awards for both his cannabis industry acumen as well as his regular legal acumen. Armstrong Teasdale has won multiple Greenway Best in the Industry awards for
Consistently.
I don't know if anybody else gives out best law firm awards for the cannabis industry, but as far as Greenway readers have been concerned, they're the cream of the crop.
Yeah.
Thank you.
So that's the biggest thing, is just to, for anybody that doesn't know your background, you've been in cannabis in Missouri since the very beginning, but even before, you were kind of there helping explain and set the framework as like MoCan trade was getting set up and things like that. Is there any victory lap you'd like to take to kind of tell everybody, like, OG,
Yeah, well, I would just say I started in the space in 2014, shortly after I joined Armstrong Teasdale that summer. Got the opportunity to work with Mitch Myers, who I think almost everybody should know. She was leading a group in Illinois to apply for some licenses. And so we got involved there, and they had some success, and that started me down the path. And from there, we worked with Mitch again in Missouri when they had the old CBD oil licenses that Eric Schmidt had championed the cause for. And they got one of those. And so then it just sort of dovetailed into the campaign to pass medical marijuana in Missouri. And so I was involved at that stage, but also involved in, helping to found MoCan Trade. It was an idea to sort of get ahead of the trade associations and competing with one another. If there were different ones for different areas of the industry, the thought was, well, we'll just cast a big net and get everybody under the same tent. We'll all work together. And it worked out beautifully. We got very lucky with getting the right people in the right positions. And a lot of people were very invested in seeing it be successful. And that's why, I think we're pretty proud of like that article in the Wall Street Journal about Missouri as the gem of the industry nationwide. And it is. It's a great area. And I have clients who come from other states and they say it's not like this from our state. People aren't as collegial. People don't talk between themselves. It's very hyper competitive. And I'm glad we've kind of set a good standard for everyone else to try and follow.
Absolutely. It is a consistent talking point when we have guests on talking about the Missouri industry and how we all kind of get along. And these MoCan meetups and stuff like that, there's no fights breaking out. Everybody's having a good time, shaking hands, cheering on other brands. It's great. But I will say, Eric, to get the Mitch Myers seal of approval, you might be the first in the industry to have it, because I know whenever I brought you up early on, Mitch was like, Eric is amazing. I love Eric. And I was like, who is this Eric guy? How did he get such high praise from the Queen? And I mean, it's justified. You've done amazing work here, and especially with MoCan, and people go to you a lot for issues. So it's an honor for you to be here with us today. That is for sure.
It is.
That is for sure. One thing that I have been extremely excited about is the rescheduling. Eric, Brandon and I did a whole episode talking about rescheduling, but it was hours after it happened. And so we didn't release it because a lot of our ideas and a lot of what we said probably was factually incorrect because we didn't really know how it was working at that point.
It was me. It was me.
No, it was me too, dude. Me. Trust me.
I did not read all of it. It was very clickbaity. I read the top and I was like, "Fuck yeah, let's talk, Tim." You gotta read the rest. You gotta go beyond the. That's why we don't have paywalls, guys. That's why we don't have paywalls. Is because I'm not gonna pay the Wall Street Journal a penny to go and read real journalism.
Yes.
That way you could offer a free money back guarantee, right?
Yeah,
that's right.
Sure. Yeah. So, okay. So Eric, if you could do me a favor, and I'm acting like I know a lot about it, but I don't. Let's just say I don't. How would this rescheduling, how would it affect me as a resident of Missouri in a market that already has medical and recreational use?
Well, to start out, I'll say this whole rescheduling thing is still very fresh, and it's a little unclear how many of these nuances are going to shake out. But I think for the average consumer in Missouri, I don't know that you're going to see a lot of change. It's still going to be, on the heels of, let's say that there's clarity that the rescheduling would be applicable to Missouri comprehensive licenses. And we can talk about why I put that caveat there. But assuming it were, then you would be buying and consuming a Schedule III substance instead of a Schedule I substance. And so it's just how to have a lower profile from like a criminal law enforcement standpoint. If that was a concern, it's lower. It's still not being dispensed in the manner that Schedule III substances are typically dispensed, though. So it is still outside of all of the regulatory boundaries. One other way that a consumer might be affected is that as a result of rescheduling, if that carries over to the facility licensees being unaffected by 280E and able to take normal business deductions, that may translate into price drops because it just from the wholesale side, it'll cost less because the tax burden will be lessened. But beyond that, I don't know that there's too many more impacts on the average consumer.
So did you, there was talk of wanting to do this and rescheduling and everything. And then at least to me, it came out of the blue. Did you know this was going to happen like overnight? Okay.
No.
Neither did any of us.
I don't really know the timing, and I don't know why when the decision was made to go forward with it, it was done in sort of a hasty way. As I understand the cadence, the Attorney General has the ability to to promulgate this order that's been put out. That's what got us through to this point with medical. And as I understand it, I could be wrong on this, it has to do with that convention, that international treaty. And it basically, I think it allows for changes to how these substances are handled under that treaty if there are medical reasons. So that's why they could do it sort of lickety split by this order. But as to adult use, they've scheduled an expedited administrative hearing on June 29th. And so they're going to hurry up and decide, I guess, whether non-medical marijuana is going to be rescheduled, or they're going to hurry up and decide that it's not going to be rescheduled. And I don't know what direction it's going to go. It seems like it would be difficult to say, well, it's okay because it has this medical use, and so we'll call it Schedule 3. But to the extent it's not being used for medical, we're going to leave it on Schedule 1. Because it seems like it's just, does it have a medical purpose or not? Is it highly addictive or not? That's how the scheduling is usually derived.
Mm-hmm.
But I do know that there are some examples. I was told, and I don't have a lot of experience with this, but somebody said that, opiates, for example, in different forms are differently scheduled depending on the usage. So it's possible that we have that scenario.
Okay. So I know that this is hypothetical as well, but if I lived in Kansas and I woke up to that news, I would be excited. I'd be like, oh, hey, cool. Hey, now something may change. Is anything really changing for a state that doesn't have any sort of medical marijuana program?
I wouldn't say so, because rescheduling is not decriminalization.
Mm-hmm.
Rescheduling is not everybody can have it anytime they want.
Right.
It's really just lowering the federal barrier and the federal viewpoint on it. I guess if you live in Kansas and if you are a consumer and you don't drive to Missouri or some other state where it's legal to get so you're buying from the gray market or the black market, you're facing less sort of criminal exposure, I think, if it's a Schedule 3 substance instead of a Schedule 1 substance, assuming
Right,
that it goes through for non-medical. The only way you could legitimately say, well, I mean, you could argue with it. Well, I bought it for medical reasons, even though we don't have a medical program.
right.
But that's going to be a hard argument to make without a program.
As of
Mm-hmm.
today, it would have like no impact on any person in any state that doesn't have an existing medical marijuana program or anything.
Not directly, but it could inspire a state like Kansas that has said no,
Yeah.
to revisit their policy choice to not have a medical marijuana program, a regulated medical marijuana program, in light of the federal government even admitting, okay, we recognize there are plenty of medical uses.
Now, I'm gonna cut in for a second real quick because I have one more hypothetical on this, and then we got to move forward a little bit because we can only afford like maybe a half of your hourly fee. So
I knew he was going to.
we gotta milk the blood from the stone right now. Hypothetically, say that they come back and they say we're not going to reschedule adult use at all. In fact, we're going to keep adult use 100% prohibited. That opens up a lot of questions and a lot of possibilities and things like that. But Missouri would be one of the few states that would still be intrinsically outside of that box, essentially, of reevaluation because of our program being constitutional. So in order for us to go backwards and say that we're going to delegalize adult use in Missouri, it would have to go to another vote of the public, correct?
Yes, if they wanted to eliminate adult use marijuana in Missouri, that would require a new constitutional amendment to change what was adopted with Amendment 3.
And so with us being set up constitutionally, we've had discussions previously, and I've talked to other people. It's always been my theory that Schedule 3 is not going, again, as Eric likes to tell me, I'm not an attorney. So this is not legal advice. This is me positing a theory. I've always felt that Schedule 3 was not a path forward for legalization, full legalization, because there's very few things that are, a scheduled substance that are also legal for any kind of recreational use or anything like that. And so I've always looked at it as rescheduling to Schedule 3 being a push forward for research and medical usage and access and things like that. But in the long term, I always thought that it would be the thing that drove adult use out of several markets, because if you federally legalize it, they have FDA regulations and things like that. Then in a state where it's just a state law that was passed in the legislature and they don't have to go to a vote of the people or anything like that, it seems like it would be easier to just rewrite the rules and say, hey, we're going to fall in line with whatever the federal regulations are now. And so if that were to occur, then you would have a few states left, but it would be much fewer than what we see now for you to be able to go and it would kind of be like gambling in Las Vegas and New Jersey. You know, you go there for the adult use experience rather than just the medical usage. Am I crazy is what I'm asking, Eric? Is this completely wrong, or is there some tinge of reality to my conspiracy theory and my green tinfoil hat?
I think there could be some in there, but I haven't thought of it that way exactly. I mean, when I think about like this June 29th administrative hearing, if the conclusion is that there's not an appropriate legal basis, whatever, to recognize adult use marijuana as a Schedule 3, and that it should, I guess, remain Schedule 1 would be the presumptive conclusion. Either move it to 3 or leave it on 1. It's on 1 now. We adopted Amendment 2 when it was on 1. We adopted Amendment 3 when it was on 1. Illinois and all the other states that have passed adult use did so at the time it was on Schedule 1. So if it stays on Schedule 1 as a result of all this, I don't know that would precipitate a change at the state level to recriminalize adult use and only leave medical behind. I think in a state like Missouri, where we don't have separate medical license, separate adult use license, and in some states they require actually separate inventory to be maintained. Here, everything is together, which I think makes more sense. The question then becomes is how, if at all, does a comprehensive facility licensee in Missouri, react to the Schedule 3 treatment for medical?
Well, that was one of my questions. So that's a great segue to you asking you asking yourself what I was going to ask.
Yeah.
All right, Eric, what do you think? Well, what I think is it's a little bit fuzzy. I do think that the DEA, they've opened this portal and they've invited licensees to register. And this is, again, in keeping with that international treaty, this notion that if you take a Schedule 1 substance and you make it available, the government is supposed to be the sole owner of the substance. It's supposed to be government controlled, like imagine like a big, federally owned farm or something growing all the marijuana. Well, that's not.
Sounds like socialism to me.
That sounds a little bit like that, right? And so that's where they've got this sort of fiction, almost, if you will, that everyone would register. So if you're a medical provider, you would register through this DEA portal. They'd come out and inspect your facility, and it would be some kind of sort of pseudo-federal facility in one way. And then as you made product, it would be sold to the federal government and then immediately sold back to you for distribution through the normal networks. But it's just a sort of, like
Under
I say,
the brand name Comrade Cannabis.
something like that. But the federal government wouldn't exert any controls. The only trick in there that I see is that the federal government would extract this $133 per kilogram, is I think the metric of a processing fee. So in one way, this would be a way for them to capture some, or I don't even know if they've done the numbers on all of the revenue lost by eliminating the 280E impact and making everybody pay a whole lot more in taxes. So they're going to sub in this processing fee mechanism.
It seems like they're also going to save a lot on all those drug enforcement efforts,
Yeah.
Maybe.
Yeah. Well, they're already probably saving a lot on that front. I mean, the federal government is by and large not been involved, the DOJ. I mean, there's still instances, but by and large, I mean, I don't know of any Missouri licensee that's been hassled by the federal government. So, but you're right.
To be fair,
Yeah.
They probably stopped harassing them as much whenever they started giving the cartels in Mexico the money,
Right.
and the drugs.
So I think the question would be, how would the DEA...
A reminder, I'm not an attorney. Nothing that I say represents Eric Walter in any way.
I just think it'd be interesting to see if a comprehensive facility licensee in Missouri applies in that DEA portal. Would they just say no? Because they say, well, you're not a medical licensee. Well, yeah, I am. I can sell to patients. And they could say, well, look, you have Section 1, so it provides for medical licenses. And so you're not one of those. What are we talking about?
Is this like an all dentists are doctors, but not all doctors are dentists situation?
Perhaps. Yeah.
Okay. Because, I mean, if I'm having a heart attack and I'm like, doctor, and a dentist comes up to me, I'm going to be like, no, not a real doctor is what I meant, not you were a chiropractor. Like, get out of here.
Got it.
Tim, did you have other questions?
I
feel
did.
like
Now with 6 locations across the St. Louis area, Kind Goods makes it easier than ever to shop locally for quality cannabis. This locally owned deli-style dispensary offers premium flower, personalized service, and one of the largest deli-style selections in Missouri. Visit Kind Goods in Fenton, Manchester, St. Peters, Soulard, On the Hill, or in Maryland Heights. Same standards, same care, now with more locations near you. Learn more or find your closest store at thekindgoods.com.
So here's the one I hear a lot about out here in West St. Louis County: tax stacking when it comes to cannabis. So I have an idea of what it is, but can you explain it in layman's terms?
Not only can he explain it, he can tell you how he won.
Tell us.
How we won. Well, this was actually something the trade association was leading the charge on, and kind of rounded up the industry, and we all got behind it because, the whole goal, I know when the work was being done on the constitutional amendment, some of the talk was about we've really got to get the tax rate correct. Because if you tax too high, and other states can tell you the sad stories about it, if the taxes are too high, consumers are just going to say, forget it. I'm going to go buy from, my regular dealers or whatever, and there are no taxes. So it has to be that right balance of generating some funds for good causes and for state revenues, but also making it reasonable. And so this was an allowance to say, well, let's do a 3% local tax. That was the contemplation. All right, great. And so where the tax stacking, as it were, comes in is the idea that the local government is allowed to impose an up to 3% tax if the voters approve it. And what happened is the cities that are, local governments, and then also counties that also qualify as local governments, depending on where the dispensary is located, they all went out to their voters, their local council, their governing councils all voted to do it. Then they put it on the ballots. Most of them did it in the April election in 23. Some of them did it in the August election. But by and large, most local governments passed it, even some that don't have a dispensary, just in case we're going to have this in place, right? And so where it became a problem is when a dispensary was situated within a city limit. Within a city's boundaries, the city is the local government. Now, when the sales happen at that dispensary within that city, they would collect the normal sales taxes, and a portion of those normal sales taxes go to the city, and a portion of the normal sales taxes go to the county. So the county says, well, look, we're sort of a governing body as well. We imposed the health codes, was one of the items they argued in the lawsuit. And so as a local government, we're entitled to do it. And we went to the language in the Constitution, and it says the local government. And the definition of a local government is a city, town, or village, or a county, if the dispensary is in an unincorporated area. And so the decision of how does this local government definition apply, you start with where is the dispensary situated? If it's within a city, town, or village, that's the local government. If it's in an unincorporated area of the county is the local government. And then once you know who the local government is, that's the entity that can impose the 3%. So Robust was the dispensary that was our named plaintiff in our lawsuit. And we sued St. Louis County and the Department of Revenue. And we said, hey, we're in the city of Florissant. Florissant's our local government. Irrespective of whether Florissant imposes the 3% tax, the county is not the local government and cannot impose the tax. But they did anyway. And so we challenged that on the basis that it was an unconstitutional imposition of tax. And somewhat surprisingly, we were unsuccessful at the trial court level. But I do realize that, we're in the county, we're suing the county. And unsurprisingly, the county's employee was like, I don't think you're right.
Right.
But the Court of Appeals agreed with us. And then the Supreme Court agreed with us on this core argument that it is one or the other. It can't be both.
And just to shout out our buddy Chris, the former CEO at Vertical, who's also a wonderful attorney and has a luscious head of hair. they were also trying their own version of this in St. Joseph and Buchanan County,
Yes.
the western side of the state at the same time. I always want to give credit where credit's due.
And I was happy to see that Chris also lost at Buchanan County. I felt a little better. It's like, all right.
So the end result, and part of the reason, my understanding, part of the reason the way it was written is written that way, one, to keep taxes lower for legal consumers and patients. Two, because they want the tax revenue to go towards who's providing the services for that dispensary and for those consumers and patients in that particular area. If you're stacking taxes, then you're not getting two separate sets of police officers. You're not getting two separate sets of road maintenance and things like that. But this has resulted in additional lawsuits, correct?
Correct.
Class action?
Correct.
That's a word we're going to hear a few different times today. It sounds like class action has become a big buzzword in Missouri. Just to ask, I believe I was mistaken about this. I thought that you needed more than two to certify a class. Am I wrong about that? You only need two to certify a class in a class action?
More than two what?
Entities? People participating as the class to certify the class itself?
Yeah, well, a class has to have more than two people, to be sure. It's not a fixed number, but it has to be a significant number, so many that it would be unreasonable or burdensome to really try to plead each one as an individual plaintiff party. But when you're asserting a class action, and this is an area of practice that I did a ton of work in before the marijuana stuff really took off, but to assert a plaintiff class action, you do have to have what they call a class representative, at least one. And you want that person or persons to be typical of the people who would be in the class. And before it's certified, it's called a putative class. This is what our class would be if the court agrees. And then you define, here's what it would take to be in the class. Here are all the people who have been negatively impacted by the defendant or the defendants. And then at some point down the road, there is a question of, can this class be certified? And that's a very complicated and a multi-factor test that goes into certification. But the threshold inquiry in a class action is, does the named plaintiff state a cause of action? Because if they don't have a viable claim, then it doesn't matter if there's a class of people who have the same non-viable claim. So
we have a class action pending over the tax stacking.
Correct.
What is that? Who is this class, and what are they alleging?
Correct.
Okay.
I'm sure you're not
There you go. Yeah, exactly. That's good.
And if I was a lawyer, my clients would be in trouble, because that's how long it takes me to come up with a word sometimes.
So
I would be the most dramatic, like Southern drawl lawyer while I'm giving some kind of speech in front of a jury, because there'd just be a 30-second pause, but it wouldn't be for dramatic emphasis. It'd be because I forgot a word.
But the jury doesn't have to know that, right? They'll think it's
They don't.
It's all his game, right? So this is, to some degree, when you talk about a consumer class action, you're really talking about the plaintiff's attorneys who bring these class actions. They're the ones who are sort of very creative. For example, there was a class action in which somebody brought a consumer class action of people who consumed Red Bull. And the claim was, I drank the Red Bull. I got no wings.
Right.
And they actually got paid off.
Right.
Red Bull settled that case to just make it go.
I know. It's unbelievable. So that's why they say wings, right?
Right.
That's why they have like the wings is like a bunch of eyes. It's like WIING.
Right.
Because wings, it's not giving you wings. And they lost that. So, yep. Holy cow.
Yeah. It's a lot of creativity. Now, the plaintiffs, class action attorneys would also fancy themselves as sort of mini attorney generals. They're going to bring these class actions, and they're going to right the corporate wrongs, and they're going to protect the world to the extent that the proper attorneys general aren't doing the task. So here, the claim is that the average consumer. So imagine that you're in, for example, Robust. So somebody comes into Robust and they were asked to pay the taxes that were imposed upon Robust by the Department of Revenue. They got a rate change notification that said the normal sales tax, Florison's 3%, county 3%. And that's an order. You have to do it. And if the dispensary hadn't collected the money, or more precisely, if the dispensary hadn't paid the 3% for both of them, the dispensary would have been on the hook. Because in Missouri, the idea is that the dispensary is the taxpayer. It is the one that has to remit the money. It's the one that has to pay it. It's the one that's liable if it's not paid or if it's paid the wrong amount. So the consumer, though, that comes in and let's, for ease of math, they want to buy $100 worth of product. So they get the normal sales tax or whatever, and then there's the 3%, $3 for Florissant, $3 for the county. This class action says that $3 that went to the county, that the Supreme Court has now declared to be an unconstitutional tax and subject to refund from the Department of Revenue, that money should be paid back to the consumer who paid it. So it has at first blush some logical appeal. You'd say, well, yeah, that was their money. But in a lot of states, that would make sense in the law too. But in Missouri, the law views it, as I said, that the retailer is the taxpayer. And in Missouri, the statutes that govern on this issue say that in the event that there's an entitlement to a refund, the refund belongs to the retailer, the remitter of the tax. Now, there is a procedure by which, in that scenario that I just described, the consumer who paid the $3 could apply to the Department of Revenue. There's a form they could fill out. Hey, we want this $3 back. And what DOR would say is, okay, well, you need to take this form and you got to go to the retailer and have them basically waive their claim, their statutory right to the $3 refund, and say that you can have it. And if they do that, then you can have it. And if they don't, then you can't. And so,
wow,
that's just the way it is structured. And like I say, in other states, it goes on to say, you have to go get the refund from DOR. Then you need to go on your records and you need to find your consumers. You need to try and reunite the $3 with them. Our General Assembly didn't write the statutes that way. It is a tax on the right to engage in retail sales and sell things to the public. That's what the tax is being imposed on. It's not being imposed on the purchasing of things. Just feel that.
So it's possible that you can make a case that you shouldn't be paying the sales tax every time you go to any store anyway, because that's their tax for doing business, not your tax for doing business.
Correct. But the law allows them to impose the tax as prescribed by DOR. And if you don't want to pay the tax, chances are that they won't part with the goods.
Hey, I get it.
Right.
Man.
You should argue that with the cashier at the grocery store next time you're there.
right.
Oh, trust me, I'm going to. I'm going to. Don't tempt me with another reason to be a Karen.
Eric Walsh, guess what he told me?
Yeah. I got him right here on my speed dial. You want to pay his fees? Let's go. So there is another class action lawsuit going on right now that affects Missouri as well. And that one involves cashless ATMs.
Correct. Yep.
Strom?
Your guess is as good as mine. Stromy.
Stromy?
Yeah.
Pastrami?
Maybe.
Stromboli?
Probably not.
Now I'm hungry. So let's dive kind of 10,000 foot view on. I think most people understand what a cashless ATM is that are listening to this, but why are we now involved in a class action over the cashless ATM?
Well, as a class action defense counsel, my answer to that question is almost always, well, those creative, plaintiffs attorneys, they always come up with these unique theories to claim that someone's been injured. And it just so happens they stand to gain millions of dollars potentially if it goes well. But that's not really what motivates them, I'm sure. No, I'm kidding. But I think This one is to me a little bit more of a stretch. I don't fully understand it. We've been studying it, and we're defending several of the cases, 9 separate cases, but they're materially identical, just against different dispensary operators, were filed on February 27th of this year. And the claims are essentially that consumers who would come into dispensaries and make a purchase and chose to make a purchase using the so-called cashless ATM, or the more formal term for it is a point of banking terminal, that those individuals were damaged. They suffered damages when they went in and they bought their $100 or whatever of product, and they paid using their bank card, and because there were hidden charges or hidden fees that were imposed upon them. That's the theory of the case. And the examples in the petition that were given for the hidden damages are that, so I gave the example of $100. Let's say they came in and their purchases added up to $97. Well, in a point of banking transaction, it has to be rounded up to the next $5 or $10 increment. And in Missouri, in my experience, it's mostly been $5. And so in that case, 97 rounds up to 100. And so they say, all right, we're going to round you up to $100. And then there's a little screen, and on the screen, it will say, just like when the ATM machine where you would get cash out, this screen says, there's a processing fee of, it's around $3.50, something like that. Do you agree to this? And they said, yes. And then the transaction goes through, and it was rounded up to 100. And then if it's $3.50 processing fee, it's $103.50 is what's taken from the consumer's bank. And then it goes over to, through the payment processing, and then it gets to the dispensary's account directly. And nobody has to shuffle around the cash. And then we don't have the scenario where dispensary employees are walking out at night with a big duffel bag full of cash to try and take to a bank or something. And the claim is that the consumer who engages in that transaction suffers a damage when they're asked to pay 100 instead of 97, even though the $3 difference is handed back to them.
I suffer more damage whenever I go to Starbucks and the girl holds the thing up and puts it right in my face before I've even gotten my drink. How am I supposed to tip you if I don't know whether you made my drink right? That's
Fair
insulting
point.
to me.
That's a fair point.
To be fair, I'm just a bad person, guys. I'm just a Karen.
It's not true.
I complain about a lot.
It's not true.
So I think the synopsis of the cashless ATM case is, you can't say this because you are an attorney and you have to be legally bound, but I can say that it sounds like one, and it seems a little far-fetched, but perhaps that's just me.
There is another hidden damage or hidden charge that they assess, and that is the processing fee. So there's going to be a bit of a case-specific question: is were there disclosures like I described on the screens? In my experience with my clients who looked at their systems, yeah, it said right there, you're going to get charged this fee. Do you agree? And then you have to push a button to agree. So
it's called a vice fee. They charge it at the casino. They charge it at the strip club. They charge it at the dispensary. They charge it at fast food places. Sometimes, if you go to like the convenience stores that have the ATMs right there and stuff, and they have the fried chicken in the back at the convenience store, that is just a charge for being a person that goes to places like that. That's just part of looking like I look. You look like this, they're gonna hit you with $3.50 every time you come through the door.
I was following you for a minute. I was like, what? Oh,
they do. They charge it at casinos. They charge
that is true.
Every time you run
that is true.
Somebody's got an ATM that says an extra $3.
Yeah.
One thing I know we're right up against it, but one of the most important things that I really wanted to touch on before we let you go today was you have been instrumental in and helpful in both writing and explaining the ICCA. Finally passed in Missouri this year in November. The rules changed significantly for intoxicating cannabinoid hemp products in the state of Missouri. This did a lot of different things, but for this year, the biggest thing it did was really bring Missouri in line with what is going to be happening on a federal level.
Yes.
What if anything do we not know about the ICCA? Why was it so? We've talked about it. Tim and I have talked about it, but why was it so important to get past this year? And what do we not know about it that we should be prepared for if we're a cannabis business, either a hemp business or a licensed medical marijuana business in the state?
Well, it was important because, I don't think by and large people outside the industry were really differentiating between the regulated industry on the one hand and the unregulated, hemp intoxicating product industry on the other hand. And so there was a feeling of, well, it's a lot of overlap here. And if things go sideways, like there was a story about a woman in Virginia who went to jail because she didn't put her hemp gummies away and her kid got in them and unfortunately passed away. And there was no regulation surrounding it. I don't know the details for sure, but there probably wasn't a reg that said that package had to be child resistant or opaque, or that it couldn't have all the colorful imagery that you see on these products. So there was always this concern that, the bad acts of the unregulated industry could really negatively impact the regulated industry. And it was also just an aspect of fairness. I mean, there was this, multi-decade fight to get marijuana into some kind of at least state authorized space. And then along comes the hemp industry and they're just doing whatever they want, taking credit card transactions. And we're like, hey, we got to play by these rules. You're screwing up the deal. So what the ICCA does is essentially mirror now what is happening at the federal level. The change that related to the U.S. Farm Bill's definition of hemp and clarification of the testing requirements, which are always there. It was always required. The USDA set it out there. You're testing the plant for total THC content. And that was the ignoring that was the premise of this whole loophole. They say, well, Delta 9 THC is very, very low. And yeah, there's lots of this THCA, but that's not the regulated substance. No, it's total THC, which is THCA and Delta 9 and Delta 8. Post decarb is the concept. So you assume the THCA is going to be converted over into THC Delta 9 at a 0.877 ratio. So that was the test that was always required, but they said, well, we're just going to pretend that's not there. Now that's been made more clear. It's 0.3 total, and then they add sort of belt and suspenders, a limitation of 0.4 milligrams of THC per container, which basically eliminates all of these intoxicating products. And I know that there is an effort afoot to make sure that this would not eliminate full spectrum CBD products, for example, which are not intoxicating. What the ICCA has sought to do for years is exactly that, to create this clarification that this hemp industry is not regulated. There's a regulated space if people want to get into it, if people want to operate and sell these products. They just need to go through the regulated space. They need to acquire one of these licenses. They're always being bought and sold. This year's ICCA, there was an effort to have it become effective immediately or as soon as the governor signed it. Well, that was pushed off. And then there was an effort to say, well, let's at least have it effective in August. The end of August is typically where that year's General Assembly's final and signed bills become effective. Well, no. So now it's been pegged to take effect November 12th, when the federal change is supposed to take effect as well, unless that's pushed off. And there's been efforts to push it off, and they have not apparently been very close to succeeding. So the feeling is that it will hold. And so on November 12th, under both federal and state law, there'll be no longer any theory by which you would say that these hemp products can be legally produced, legally possessed, legally sold.
There's so much more I wanted to talk to you about there.
No.
I wanted to get into the union protections that were involved in the ICCA and things like that, because you've been on both sides of the union argument at different times and are one of the most well-versed people in the state on that. In the cannabis industry. It sounds like we need to have you come back in a few months and retouch on a few of these things. But I appreciate you so much. Tim is going to pick up the tab for your hourly rate.
Okay.
He said he's got that.
Yep. Got it.
So I appreciate you coming on.
Yes.
genuinely thank you so much for everything
Yes.
you do for the industry and
Absolutely.
for taking time out of your day. We can't wait to have you back, and this is your opportunity. We'll mark it right here. We won't tell anybody. We won't share it. Just talk all the shit you want real quick. Just go ahead and let it out there.
That's funny. Eric Walter, everybody.
Yeah, right. No, thank you so much for having me on. This has been wonderful, and I would love to come back. There's never a shortage of topics to discuss in the marijuana industry.
Flower Pot NYC is America's leading brand design and packaging agency for cannabis and emerging brands. They're cannabis consumers themselves, so they design packaging that doesn't just look beautiful, it protects and showcases the integrity of the product inside. Over the next 3 months, they're offering $1,000 off your first order, plus $1,000 if you refer a brand that becomes a client. They'll even beat your current packaging invoice by 5%. Or walk away. There's some conditions that apply. I'll let them handle that. Family run, good people, great product. Flower Pot NYC. Grow with us.